Hey guys, let's talk about Mexican legal framework on international trade arbitration. What is arbitration? Arbitration is a procedure recognized by Mexican and international law, which allows individuals to resolve their commercial dispute without having to submit to national courts. Thus, individuals obtain a final and impartial award which acquires the same legal force as a legal sentence. The legal framework for the development and practice of private commercial arbitration are 1. Title 4, Book 5 of the Commercial Code, reviewed in 1993, adopting the UNCITRAL Model Law on International Commercial Arbitration. 2. The United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Award, ratified by Mexico in 1971, and 3. The Inter-American Convention on International Commercial Arbitration, ratified by Mexico in 1978. Use of commercial arbitration is growing substantially. Resolving a matter through arbitration is a natural option where company-centered analysis on the merits. The parties are foreign to contracts involving complex or technical issues that require them or have corporate headquarters abroad and deal with Mexican private or public companies. The parties wish to select a foreign governing law. The parties want to depart from the formalities of Mexican procedural status and court practices. It is necessary or desirable to have a multicultural tribunal that can understand different systems of law. It is necessary to have an arbitral tribunal that can conduct the proceedings in one or more foreign languages or apply foreign law. Confidentiality must be kept with regard to the parties or the facts surrounding the dispute. Arbitration is commonly used in disputes in the following industries: public procurement, oil and gas, construction and infrastructure, joint ventures and commercial transactions involving complex application of law or high monetary value. Recent trends. The use of arbitration is growing throughout the country. Arbitration clauses are becoming a common practice in mid-sized and large transactions. State-owned companies, such as the oil and gas company Petróleos Mexicanos and Comisión Federal de Electricidad, are currently including International Chamber of Commerce, London Court of International Arbitration, and ad hoc arbitration clauses to settle disputes arising from the contracts that they execute with private parties. Advantages of arbitration in Mexico: avoiding the stringent formalities required in Mexican court proceedings. The judiciary's increasing support of arbitration and of enforcing awards rather than annulling them. The alignment of the legal framework with the United Nations Commission on International Trade Law Model Law on International Commercial Arbitration 1985, UNCITRAL Model Law, and the 1975 Inter-American Convention on International Commercial Arbitration, the Panama Convention. The presence of a talented, world-renowned group of arbitrators and arbitration practitioners with both domestic and international exposure. The strong presence of arbitration institutions in the country, and for less frequent panels and conferences regarding arbitration which help to foster deeper knowledge of the matter. The main disadvantages are usually related to the lack of compulsory membership to a bar association, which makes it difficult to commence ethical or disciplinary proceedings for abusing arbitration or court proceedings. We also have an
dissatisfa- dissatisfaction. Sorry, too large the word. Dissatisfaction with some arbitrators, poor reasoning in the words, and high administrative costs, arbitrators' fees, and legal fees. Delays in receiving payment after an award is rendered because the time limit to seek annulment of an award is 3 months after the award has been rendered. And we also have the possibility of the losing party trying to delay payment of the award by commencing an annulment proceeding and hindering the annulment proceeding. The Mexican arbitration legal framework is embedded in the Commercial Code. The provisions in the Commercial Code directly adopt an ancestral model law with the following additional provisions. I don't really know how to pronounce that, but I will spell it. It's UNCITRAL. Model law with the following additional provisions. There is a special proceeding for commercial transactions and arbitration, Juicio Especial de Transacciones Comerciales y Arbitraje, which governs challenge to an arbitrator, directions of the arbitral tribunal, court order interim measures, enforcement of interim relief ordered by an arbitral tribunal, and proceedings to enforce and vacate arbitration awards and rules regarding joinder of these proceedings. Arbitrators are liable for damage that may arise from granting interim measures. We have some matters of public policy or public order cannot be resolved through arbitration. We have environmental law, we have family law, criminal law, tax law, employment law, antitrust law, IP law, consumer matters. The grounds for setting aside an award cannot be modified by agreement of the parties. Arbitration organizations. The Arbitration Center of Mexico, Centro de Arbitraje de México, CAM, the National Chamber of Commerce of Mexico City, Cámara Nacional de Comercio de la Ciudad de México, CANACO, International Chamber of Commerce, ICC, International Center for Dispute Resolution, ICDR, and CANARO has an agreement with the ICDR to administer disputes under the ICDR rules in Mexico. And that's all. And have a nice day. Sorry.